Welcome, everyone, to the Legacy Years podcast. I'm Kristy Osborn with Fairway Mortgage. And today's episode is one that I really have been wanting to do for a while. I feel like I talk to a lot of folks who say, well, the house is going to go to Billy. Oh, and everyone knows it. But they think that's a plan. But it is not actually a plan. And intent is not the same as what legally happens to a property when someone passes away. So today we're going to talk a little bit about property title. How does it transfer? What really happens when someone passes away? I think this is especially important here in Texas, where the rules can be very specific, and what you assume will happen isn't always what happens. And I'm honored to have Mike Vullo with us today. Around here, he's known as the grandfather of title. He has spent decades in this industry and has seen just about every scenario you can imagine, the smooth ones and the messy ones. Our goal today is simple. We want to help you understand why properly handling title isn't just paperwork. It's a gift to your family. It prevents confusion, delays, sometimes very expensive problems down the road. If you own a home or expect to inherit one someday, this conversation matters more than you think. So let's get into it. Welcome, Mike.
Good morning. Good morning. How you doing, Kristy?
I'm doing good. I am so glad that you agreed and had time on your schedule to get into this with us, because it surprises me, honestly, still in this day and age, when someone says to me, the house is going to Billy, and everybody knows it. And I think in my head, boy, that's not how it works. So why doesn't it work that way? Let's talk a little bit about legally transferring ownership and why that doesn't work. Particularly, folks, we're in Texas. We're talking about the state of Texas. Neither Mike nor myself are an attorney. We both just have a lot of experience in real estate. So we're going to tell you from our layman's opinion what happens.
Gotcha. Well, of course, it probably should all go to Billy because we know Mama loved Billy the most, right?
Right?
So it really should go to Billy because he was the favorite. But no, that is kind of a common scenario that we do hear from time to time. There's no doubt about it. And of course, there's always a situation of, well, hey, we're not worried about Jimmy over here because Jimmy never did anything and we haven't even seen him in 30 years. So he's out of the picture. So yeah, those are just those are natural emotions talking. Very understandable. I would probably react the same way if I wasn't in the business per se. But the reason, of course, it doesn't, and a lot of people do, there's so many things that come into it, so many different scenarios. And the key issue, I guess, is because Texas, and there are a lot of other states, I can't name them, but some states in the U.S. are called community property states. Some other states they deal with survivorship. The big difference is, here's the big difference. So that the basic where the issue comes in, if you're in a state where it says you're in the survivorship state, that means whoever's on the deed with you, if there's two people on that deed, whoever passes away first, then who is left on that deed, they quote survive. So they're now on the title. End of story. Texas and a lot of other states are not that way, being a community property state. And because Texas is trying to protect the heirs, they have what they call descent and distribution laws in the state of Texas. And so that's what rules the roost. So it doesn't matter what title company you're dealing with. It's irrelevant. We all are supposed to adhere to those, what we call the laws of descent and distribution, according to the state of Texas. That's what's going to rule the roost. So because of that, when either mom or dad passes away, it doesn't always go to the surviving spouse. It doesn't always go to the person left on the deed with that person who passed away because of being a community property state. I guess that's the beginning.
Yeah. And so what we find is maybe that's not an issue while mom or dad are still alive. It may not even come up. So it may be years later where someone else is trying to divest of that property, sell it, refinance it, whatever, and now they've got a cloud on title. So can you talk a little bit about what that means? What's a cloud on title?
Right. Yeah, cloud on title can be many faceted. It could either be a judgment that's against someone's name. It could be a state tax lien. It could be a bankruptcy. It could be a federal tax lien. It could be property taxes. So a cloud is where either title is not clear because of the descent laws, the inheritance, or because someone has filed various liens or back taxes. So a cloud means there's something standing in the way there. Someone's making a claim as to an interest or money due on that property. That creates the
Mhm.
cloud. That means a title company sitting there stating, we can't issue our quote clear title to this new buyer. We've got some issues that we've got to clear out and we got to work up. That's what it means when we say a cloud on the title.
So now the real world consequence of that is that they got to figure that out and they got to divest of all these other people's interests before they
Right.
can do anything.
Right. And so getting back to a cloud as far as someone passing away, okay, well, here's how a cloud is created then. The simple scenario, the ideal scenario is where, first of all, the real ideal is where the person who passed away had a will and the will was probated. Now, that's your total ideal situation because now we have a will. It's been probated and we have something to follow. And it says exactly who inherits that property because now we hope that in the will, now sometimes there's issues with the will. I'm going to be very honest about that, but that's as close to the ideal as we can get. We'll talk about that in a minute too. But what really creates a cloud is when, okay, the person passed away either with no will or they could have had a will, but no one ever took it and had it probated through the court. And you're only given 4 years after someone has passed away to probate that will. Once you go past 4 years after that person's passed away, it's not completely impossible, but it's close to trying to get that will probated. So there is where the problems start kicking in, right there,
Hmm.
about what's now going to create the cloud on the title.
Right. So in Texas, we say in the real estate world, intestate or testate. And all that really means is with a will or without a will. Right.
Correct. Yeah, correct.
Okay.
Intestate means without a will.
So if someone is intestate or if someone waited too long, like you just mentioned, they had a will, but they didn't do anything with it, what happens then?
Yeah. So here's what happens then. So the the laws give a resolution as to okay, what can be done to deal with this. Okay, they give an out, they give an option, and that option is to prepare what we call affidavits of heirship. Most of the time, that works. Every once in a while, it doesn't. We can talk about it, but an affidavit of heirship. So the good thing, the state of Texas gives everyone a way to try to clear
Mm,
the title. So think about it. The whole key is we're trying to determine who has inherited this property from that person. So if you have a will that was never probated and either they don't want to, even though there's still time, or if it's gone past the time. So an affidavit of heirship is where it's a fact gathering document about the
mhm,
person who passed away, meaning we're going to literally create like a little family tree. We're going to trace the history of that person who passed away. Who were they married to? When were they married? What are the dates of the marriage? How did those marriages end? What children were born to which marriage? So we're creating like a mini family tree. We need to know everything we can know and learn about this person who passed away because we have to be able to prove beyond a doubt Do we really have the heirs? Do we really know who this passes to? So the affidavit is signed by a close family member. It could be the surviving wife or a spouse, husband, either one, or one of the children. But we need the affidavit of heirship to be signed by a family member, but then it has to be witnessed. We call them affiants, by two persons who can say they swear they knew that deceased person for a minimum of 10 years or longer, and that everything that's being said about this person is all true and correct. And so we need that because we feel like, okay, if the person giving us the information, their close family, we have two people um, on sworn affidavits notarized acknowledging all this, then our underwriters feel comfortable stating, okay, then we're going to rely on this information as to establishing who has now inherited. That's what we
And
do.
are there times where an heirship affidavit is not enough, or is it pretty widely accepted?
It's pretty wide accepted now. The difference is there's certain scenarios. If the date of death, we like to wait a minimum 6 months to a year. Now, can there be exceptions to the rule? There can be, but we have to
Mhm.
be very careful. But we like to wait a minimum of 6 months, 6 to 12 months after the date of death before we agree to close on these affidavits of heirship. And for this reason, we have to be very concerned about debts of the estate. Are there debts? Meaning there could be credit card debts, there could be last illness expenses, could be
Mhm.
hospital debts, doctor bills, you name it. They could be out there. And just like a person is given 4 years to probate a will, well, creditors are also given 4 years where they can bring a claim against the estate for money owed to them. There could be Medicaid involved. The person who passed away might have had Medicaid. They might have received Medicaid benefits. We've got to know all of that because,
Okay.
again, if we close too quickly, then boom, here come these creditors. And just because we've closed doesn't mean everything is okay, because they could take that
Right.
to court and they could sue the estate. And now we got a big problem. We've closed, we've issued title, and boy, we have a problem now. So that's the reason for the need to wait 6 to 12 months if we're going to rely on it. Again, can there be exceptions to the rule? There can be. The circumstances have to be really pretty clean for our underwriting attorneys to approve such a thing. So again, now, is that the answer to everything? Can somebody say, well, okay, hey, let's just do the affidavits of heirship? Well, it still doesn't always clear everything up. And so why not? Well, once we start asking questions about what's happened, then there's where things start getting interesting.
Right. Because you might have some complications because while that affidavit of heirship is identifying the heirs, sometimes it's identifying heirs that now create an issue, correct? We've got blended families, second marriages. I mean, it's the list can go on and on as to who might now be in that title, right?
Oh, no doubt about it. And I guess we could talk about that now a little if you want to, like
Yeah.
what can happen. So we have, again, let's keep in mind now, a while ago we talked about community property versus right of survivorship states. Well, w- here's the two other keywords: community property versus separate property. It Again, the state, they have guidelines. What happens to a person's estate? But we have to determine, well, was this the deceased person's community property or was it separate property?
Mhm.
That makes a big difference of who gets thrown into the chain of title when that person passes away. I'm not going to get into all the scenarios. It's not important at the moment. The key thing is when you determine if it's community or separate, okay, now we have to follow those guidelines. Does a
Hmm.
surviving spouse come in? So here we call, like you mentioned about the blended families, more than one marriages. Now we start getting into children that were born to the deceased. The ideal situation is where it doesn't really matter maybe how many times that person was married, but what children born to this person. If the only children born to this person were children born between that person and the person they owned the property with, the spouse, and it was community property, bought it together, it's a no-brainer. Title will all pass to the surviving spouse, but that's not always the case.
That's the easy peasy one.
Yeah, you have multiple marriages, children born by different marriages. So now, again, the state makes it very clear. Well, if there were children born not only to this marriage, but by other marriages or other persons, now that person's interest does not pass to the surviving spouse. That interest goes to their children and art. So that's when here we go with the family tree. So what can go wrong there, right? That sounds pretty simple. What could possibly go wrong?
What
Nothing.
could possibly go wrong?
You know. Well, this is where I wish we could say, well, hey, wait, let's go back to love Billy the most. So let's just give title to Billy and forget all this, right? So what could go wrong? Well, what goes wrong is here we go. What children are out there? Can we
Hmm.
find them? And are they alive? Sometimes those children have now passed away. Now, those children, now the grandchildren of the deceased come
Yeah.
into the picture. This is where things get complicated. And this is where people's nose can get pretty out of joint because now it's throwing people in the chain that they don't even know. They may not even know these heirs. And trust me, that happens every day, every day.
Yeah. And so if someone's in that chain and they don't want to cooperate or they're not willing to divest, meaning just give up their interest, what happens?
Then there's a problem. Then that means we can't issue that clear title. So sometimes we tell them you're going to have to seek legal counsel and sounds like you're going to have to go to court and
Mm,
try to obtain a court order in order to get the property sold. Meaning that, okay, sometimes if you can't find the heirs, that's a real big issue, but that's where you go to court. And so again, there's different
yeah.
options the court gives. Maybe appointing a receiver to act on behalf of the unknown heirs of someone, because the court will then appoint a special attorney to handle things of that nature. And so what it means though then is that then here we have a seller, let's say, has signed a contract, thought they owned it totally, and they were going to get X amount of dollars. And okay, we can say, look, there's a way to close it. You're going to need to seek legal counsel, but just know this much. Maybe half of the money is going to go into the court, into the registry of the court. So, yeah, we can get it sold, maybe with special court orders, but you're not going to receive all the money right away. Then
Yeah.
that's a problem because they were depending on that money.
Mm.
So that's what can happen.
I think we see it too as lenders on the refinance side where someone needs to refinance their home for whatever reason, but now all of a sudden it's come up they don't own their entire home. And so that becomes an issue and we can't help them with the refinance without clearing that up.
No, very true. And unfortunately, that happens too, because
Mm.
in most cases, we find that people, and maybe that spouse passed away 10, 15 years ago, and they thought
Mhm.
everything was fine. They just assumed title passed to them because they were on the deed,
Yeah.
right? Hey, I'm the spouse. And they just assumed it. which is very normal.
Mm-hmm.
However, then, like you said, maybe they're not trying to sell, but they're trying to get a mortgage, a refinance, a reverse mortgage, a home equity. And all of a
Mm-hmm.
sudden, here the title company uncovers all of this and they come to realize, oh my goodness, they only own 50%. And
Yeah.
that is a big shock.
Yeah, for sure. And so unfortunate. I mean, it saddens me when I find people in that situation because there's not a whole lot that can be done at that point if the other person either they can't find them, like you mentioned, or they refuse to cooperate.
Yeah, it is sad too. We do see, you're right. It's so unfortunate,
Mhm.
very sad because people get hurt. They get
Yeah.
hurt.
So, a lot of people talk about, and I think this is a very common thing that I hear even outside of the real estate industry now, Ladybird Johnson deeds or transfer on death deeds. Can you just tell people simply kind of what those are and when you see those?
Sure. Um, the transfer on death deeds are fairly new to Texas. And I say fairly new, um, maybe within the last 5 to 10 years, something like that. Transfer
That's
on
new to
death.
you. That's new to you,
Yeah.
Mike.
See, it's new to me, so those are fairly new. Um, so it's probably been a good 5 years, maybe a little somewhere between 5 and 10, that the state of Texas started recognizing and acknowledging transfer on death deeds. The Ladybird deeds have been around for a long time, way, way back. And of course, that came from, if you know Texas political history, Lady Bird Johnson, Lyndon Johnson's wife. That's kind of how that term originated. And because they owned a lot of property, land, et cetera, et cetera. And although it wasn't supposed to be named after her per se, it came up out of different real estate dealings on how to protect their interest in property, what to do. So here's the deal. So it happened because of Lady Bird
Mhm.
and LBJ dealing in real estate from time to time that this came about. So a Lady Bird deed is a deed where it's a lot of good to both of these and the transfer. And here's the difference. Ladybird deed says that, okay, this is my personal residence, and you can do it. You can do it mainly on your personal residence, your homestead.
Okay.
So let's say you're my daughter, you're my wife, you're somebody. I'm going to convey. I said, look, we want to try to avoid probate,
Mhm.
and so I'm going to convey the property, you know, to my son, my daughter, but I'm going to retain the right to live there as long as I'm alive.
Okay.
I'm not going to give that up because this is my homestead and I want to stay here as long as I can. And so the good thing about that too is that the appraisal districts recognize that. So they will allow you to continue to maintain and keep your exemptions, homestead, over 65, disability, whatever exemptions you have, because you're not giving that up. So I've conveyed the property, let's say, to my son. I have a conveyance team, but I'm retaining the right to live there. So now the pros and the cons are that, well, if I want to sell that property, if the verbiage is not done, if the verbiage is
Mhm.
done correctly, great. I can still sell or refinance that property, whatever, without the joinder of that son. If the verbiage is not done correctly, sometimes it takes both of them to join in on everything, whether it's to sell it or refinance or do or borrow money, use it for collateral. So that can happen depending if the verbiage is done correctly or not. So that's the advantage of it. The transfer on death deed is a little more, in a way, a little more clear to a here's the deal. So now I'm going to convey to my son, but it says that the title and now these deeds are recorded.
Okay.
Yeah, but what it says though is that that title does not transfer until I pass away, period. So I can revoke that deed at any time. If I want to change my mind, I can revoke it. Or the good thing, as long as I'm alive, Title has not transferred. I can still do whatever I want. That's still mine. I don't have to have the son join in whatsoever. But then the good thing is that when I pass away, again, it can help avoid probate. The minute I
Okay.
pass away, boom, title transfers.
Got it. So both of them, you do go ahead in every case and record that in the chain of title?
Absolutely. And very important. We've seen instances where somebody walked around with one of those deeds and then waited till the person passed away. Then they recorded it. Now it's too late. They waited too long. The deed needs to be filed of record while both parties alive, especially the grantor, meaning me, the person that holds the title. It needs to be recorded right away while that person's still living. If they wait till the person passes away, they just missed the window. It's too late.
Got it. Got it. Okay. So we've given people quite a bit of information. I think
Sorry.
probably the most important thing is you got to do something with your property. Don't just say, I'm going to give it to Billy. So, if you could give our Texas homeowners just one practical step of something they could do to make sure that there's not that chaos, that their spouse is taken care of or their children are taken care of, what would that be?
I think the most important thing really, I would it doesn't have to be expensive. I would absolutely please advise them to contact legal counsel, sit down with an attorney, because as you can see, there are options. The
Yeah.
attorney may decide, let's do a will and have a will prepared and have it ready. They may do that anyway. They may have to say, hey, we need to set up a trust and put all the property in the name of the trust. So I would say my big thing to anyone, my single best advice is, and again, it doesn't have to cost an arm and a leg. It's not that old expensive. And to think about the money and the problems it can save later, it more
Yeah.
than can pay for itself. I would say sit down with a good attorney and lay the plan out and get it taken care of and then sit back and relax and don't worry about it.
Yeah. I think if you care about your family, it's something that everyone should do. And I think you're right. I think a lot of people think that that is an expensive conversation, but it doesn't have to be.
No, it really doesn't have to be. Sure, if you own quite a bit of properties and you have a pretty big estate, okay, there could be a lot of planning. Yeah, but still a good financial plan,
Yeah.
it might entail both an attorney and a good CPA. It will
Hmm.
pay off wonderfully. It'll more than pay for itself.
Yeah. Well, Mike, thank you so much for your time today. I appreciate your knowledge. I do think this is something that people really don't understand. So I'm glad that we were able to convey this information and hopefully it helps someone.
I hope it has. No, my pleasure. I welcome the opportunity. Okay. My pleasure. Thank you very much for all you do out there as well, too, for what you're doing for everyone. Keep it up. Keep up the good work.
Thank you.